Alright guys, so for this lecture, I'm going to be covering causation in a bit more detail. So, I think the biggest part of causation is the but-for test. And it basically states, but for the defendant's conduct, would the claimant have suffered the loss? And an important case here to refer to is Barnett. So in Barnett, the man went to the doctors just sent him off to the GP. Turns out he actually had arsenic poisoning and died. And the courts held that yes, there was a breach of his duty by sending the man off to the GP rather than looking after him and finding out what was wrong, but he was beyond help by the time he arrived at the hospital. They wouldn't have been able to help him, they wouldn't have been able to save him, and so his death was a result of the arsenic poisoning, not the breach. To be able to claim the breach has to directly be the factual or the legal cause, if not both, of the loss suffered. An important thing to look at here is the all or nothing principle. I don't like the name because when I think all or nothing, I think 100% or 0%. It's not. The standard of proof here is on the balance of probabilities. So you have to reach 51%. You have to have the majority for this risk to occur. So in Hodson, child fell 12 feet, went to the doctors, they didn't actually realise the extent of his injuries, sent him home, he came back I think 5 days later and he ended up suffering disabilities. It was found that had he been dealt with initially, there would have been a 25% chance of him avoiding disability. However, because this doesn't satisfy the balance of probabilities, it's under the 51% requirement, he wasn't able to claim on this because the concept basically states if it's the 51%, it was going to happen anyway. If it's under that 51%, it was going to happen anyway. Why should they be found liable? It's unfair to do this to the defendant. Again, you can look at Wilshire. That's another case that supports this. So there was a premature baby. They'd incorrectly inserted a catheter into him, and the baby was blind. However, there were 5 different competing causes for this blindness. So let's say each one was 20%. There's an 80% chance this child would have been blind anyway. I'm making up numbers, but it's just to put it into perspective. 80% this child would have become blind anyway. They can't claim for that. It's not on the balance of probabilities. I think there's also another case, Greg. So he went to the doctors with a lump. The doctor said it was fatty tissue. He misdiagnosed him, and because of his late diagnosis, his chance of survival went from 42% to 25%. So they said they can't compensate for that loss of chance. However, I think an important question is, what if rather than 42% of recovery, like survival, he had a 51% chance? That's one of my tutorial leaders discussed that with us. He was like, if it's above the probability, the balance of probabilities, maybe that claim can exist for the loss of chance. Don't automatically just take it as loss of chance can't be compensated. Discuss that it may be possible, maybe they can work around the but-for rule in this manner. It will give you something a little extra that I don't think a lot of people realise. I basically took it as if it's a loss of chance, you're not going to get recovery at all. My tutorial leader raised this with me. So considering at his stage in his career, he's thought about this. I think it's an important thing that we should recognise. There's a lot of problems with the but-for test. You can say it doesn't really provide a lot of fairness and all these things. And you can argue that maybe we need to take different approaches to it. So there's Canadian and American approaches where they basically split liability. We don't really have that a lot in the UK. We'll see that with the later cases we discuss. But Cook is a Canadian case. So there were 2 hunters and they negligently fired their guns. And then the claimant was shot in the process. They couldn't establish who hit him. It was unclear whose bullet it was, who caused them the harm. But they both basically committed the exact same act. So they split liability between them to the claimant. It's quite similar in Sindel, which is in the American case. So there was a drug, it was produced by various manufacturers, and so there's no way the claimant would have been able to show which manufacturer was the cause of her loss. So what they did was they looked at the market shares of these manufacturers and split liability according to those market shares. So if you had more market shares, you'd pay more of the damages, but you wouldn't get that same damage every single time from every single manufacturer. They basically said, okay, if it's £1 million, I don't know how much it was, £1 million, split that according to the market shares. So in total, she'd get £1 million, not £1 million from every single manufacturer, if that's clear. By the way, if you guys have any questions for any of the lectures, I think leave a comment, or I'll try to respond to them, clarify any things which are uncertain. Anyway, so we can move on to exceptions to the but-for test, because as mentioned before, it's not always very fair. It doesn't always give a just outcome, and so exceptions have arisen to it. So these include supervening events. There's the MCGHEE and Fairchild principle, and also the vindication of rights. So talking about supervening events, this is basically where one thing's happened and another's followed, and you have to look at, is it fair enough to put all this liability on this defendant for everything that's followed, even though they didn't carry through? So there's this case of Baker, where he was in an accident, damaged his leg, and he ended up working in a new place. And at this job, he was shot by 2 robbers in the same leg, which was injured in his accident. These were 2 concurrent events, and concurrent causes. It was the same leg. His injury worsened, and the question arose as to, okay, so who do you go after? Do you go after the robbers who shot him after the injury, or do you go after the driver who was the original cause of the injury? And they decided that the driver's better to sue. Mainly this is because drivers have insurance. It's in the UK, you have to have insurance as a driver. It's a legal requirement, and that's in place so that you can't avoid your liability. If there's been an accident, that money is there to pay for that. It's there to cover that. Also, as they were robbers who shot him, firstly, they'd be very hard to find. It's unlikely they'd even have the money to compensate him. The main thing in tort law is you have to look at who is better to go after. That's the same thing with employers. Do you go after the employee, or do you go after the whole company? A lot of the time you'll go after the whole company because they have deeper pockets. You can get money out of them. You're able to be compensated for the loss that you have suffered. Right. Another case which is very interesting is Jobling. So he'd suffered injury as a result of his employer's actions. However, he also had a back issue and would have had to stop going to work eventually. So there was this issue of, okay, what do they have to be compensated for, because they were eventually going to stop working anyway. And the courts held that you're only going to be compensated for the loss caused by the employer. So if you had another 3 years of work before your back issue meant that you couldn't work, your employer has to compensate you for those 3 years that you have been prevented from being able to continue. They can't be forced to compensate you for something that was going to happen anyway. Right. We then move on to the MCGHEE and Fairchild principle. So in MCGHEE, it was about dermatitis. So they got dermatitis from exposure to brick dust. It was expected in their field of work. They're clear, okay, I'm going to be exposed to this. However, at their workplace, there were no washing facilities provided. So they basically had an excess exposure. They were exposed for longer than they needed to be. They weren't just exposed at work. They were exposed from the time that they finished work up until they got home, got into the shower, got rid of everything that was on them. So you could say that the fact that they hadn't provided these washing facilities, allowing them to reduce this exposure, acted as a material increase to the risk. So it wouldn't have satisfied the but-for test. You wouldn't say, but for, if I'd washed it, the 51% chance. There's a material increase in the risk. You've made this person more vulnerable to suffering this loss, and you should be found liable for that. In Fairchild, it's also quite similar. It was they were exposed to asbestos. This resulted in them suffering from mesothelioma. And they had various employees in their lifetime. They were exposed various times. And with asbestos, it's one specific thing that will trigger this. It will cause mesothelioma. You can't establish exactly which provider, what day, when it happened. And it would be unfair to say you're unable to claim because you can't prove on the balance of probabilities this defendant caused it, this employer was responsible. So they found all the employers liable. They all contributed to this risk, this harm that was suffered. So this principle, it's not used widely. You have to meet certain requirements for it. So first of all, the claimant has to show that it's impossible to prove exactly how the injury was caused. You can't prove exactly when, where, how it happened, but it did. Then you have to establish that were at least two sources which may be responsible. So it doesn't mean 2 and 2 only, at least. So even if you went through 15 employers, you were exposed 15 times, if not more. Any one of these could have been the cause, could have been what triggered that damage to occur. Thirdly, it has to be the same cause of agent or mechanism. So you can't go from one dangerous chemical to another. It has to be the same kind of exposure all the time for it to be. It leads on to the first point. You can't show exactly how it was caused. You have to have the same kind of exposure every time. And fourth of all, the defendant's conduct must have been capable of causing the claimant's injury. So if they provided all these precautions, all these ways to prevent it, that there's no way that you could have suffered that loss with that defendant, you won't meet the requirements. So if their conduct, such as the failure to provide washing facilities, that's capable of causing that injury, that means that they did satisfy this requirement. So if you can establish those, you can use this principle. You don't have to rely on the but-for test. Lastly, we can look at vindication of rights and also loss of chance. So I think an important thing to talk about here is the fact that when patients aren't given the chance to consider the risks, which is the case in Chester and Usher. That's also discussed in one of the previous lectures. So the patient asked the doctor, what's the chance I'll end up with, I think, paralysis? He responded with, well, I haven't crippled anyone yet. He hadn't answered the question. He did not give the patient the chance to consider this risk. And the patient did say she would have done the surgery anyway. And it's important to note there was nothing wrong with the surgery. The surgery wasn't done negligently at all. Everything was right. She was just that one in how many. The court said because she wasn't given the opportunity to consider the risk, the defendant is liable. You have to give your patients the chance to make that informed consent, to make their own decisions. Again, we can refer to Gregg and Scott. In fact, the loss of chance issue. Should this be changed in a way? Should you allow for loss of chance? Should that be put on the balance of probabilities? There's a lot of issues you can raise with this, especially if it comes up in an essay question. You can criticize it, analyze. Lastly, we can look at Bailey. So this test was relaxed due to the material contribution from the defendant. So the patient went in to have a gallstone removed. There were several complications. They had to have several operations due to this negligence. And in the end, the patient was in such a weakened state that they aspirated on their own vomit because they were so weakened and exhausted from all of these surgeries from this negligence. Had they not, so on the but-for test alone, they wouldn't have been able to succeed, but because of all these different surgeries from all this negligence that's occurred, that test was relaxed in order to give the claimant the opportunity to have a successful claim where it would have been unfair not to otherwise. Right. Lastly, I'd like to discuss the assessment of damages under the Fairchild principle. So in Fairchild, what they did was all the defendants were liable, all of them paid. In Baker, they paid proportionate to their contribution. So say if you worked with this defendant for 1 year, this defendant for 10, the one who you worked with for 10 years would have paid more. However, this was reversed in the Compensation Act of 2006, Section 3. So it basically says, this is in cases where negligence causes mesothelioma. They say that one defendant is liable for all the damages. So you say that this was done in order to prevent them having to spend a lot of money going after all these different defendants. You go after the one of them, if your claim's successful, then you can get all of your money in one go. And this both has a lot of advantages and disadvantages. I say if it comes up in an essay question, make sure you comment on the advantages and disadvantages. Say if it also give an opinion. What do you think would have been the better approach? All defendants liable in accordance to their contribution, or this. Don't be afraid to share your opinions on the topics. Okay, and that's all.